However, we, just like any other bail application, Your Worship, in order to avoid proceeding by ambush, we seek an adjournment to verify the issue is presented because they are far away from the jurisdiction of this honorable court.
So yes, Chief State Attorney Eviroment, is this court empowered to vote for one Article 23, 6B?
Yes, it is still. It is whether or not it is a discretion of this court.
That question, that article takes away the discretion of this court. It tells the court to impose conditions that are reasonable.
Thank you.
My view.
Yes, Your Worship, whereas that is very true. Court is obliged to impose those conditions depending on the circumstances. For example, if the shooters are within the jurisdiction and authentic, court would impose different conditions from where the shooters are out of jurisdiction or they are fishing. So this is something that we need to actually find out, Your Worship, and bring to your attention. And we believe, Your Worship, that with this, it would be easier for you to make an authentic, uninformed, and a reasoned ruling.
Chief State Attorney Eviroment, supposing the way the shooters are not substantial, what happens in the light of Article 26, 6B?
Yes, I understand.
Can I bail?
Your Worship, still, if prosecution is ready to proceed, you can deny bail. You see, the most important thing is court to make circumstantial directives that are not only intended to have the accused person returned to court, but also to serve justice. Because this is a matter which is a bit complex, it's unusual, this is more of cyber, whose investigations can never be covered within the 2 months. Because of the so many technicalities involved. These are things Your Worship Court has to take into consideration. And it is our plea, Your Worship, that whereas court has the powers, we are asking as a prosecution that we be given time in the interest of justice to just verify, because it would also, court would also be taking a risk to consider a surety substantial, yet in actual sense, they are not substantial. So it is better, and it is actually better and safer to make a ruling knowing that the sureties are not substantial, but releasing the suspect on personal cognizance. And this is what we are speaking to, Your Worship.
She stays in Bumboy cell. Bumboy cell. Bumboy cell, Busamaga Westward. Industrial Division, Bari City.
The accused person from mandatory bail Judge, we do appreciate the provisions of the same. However, we, just like any other bail application, Your Worship, in order to avoid proceeding by ambush, we seek an adjournment to verify the issue is presented because they are far away from the jurisdiction of this honorable court.
So yes, Chief State Attorney Eviroment, is this court empowered to vote for one Article 23, 6B?
Yes, it is still. It is whether or not it is a discretion of this court.
That question, that article takes away the discretion of this court. It tells the court to impose conditions that are reasonable.
Thank you.
My view.
Yes, Your Worship, whereas that is very true. Court is obliged to impose those conditions depending on the circumstances. For example, if the shooters are within the jurisdiction and authentic, court would impose different conditions from where the sureties are out of jurisdiction or they are fish. So this is something that we need to actually find out, Your Worship, and bring to your attention. And we believe, Your Worship, that with this, it will be easier for you to make an authentic, uninformed, and a reasoned ruling.
Chief Secretary, supposing the way the sureties are not substantial, what happens in the light of Article 26(6)(b)?
Yes, I understand.
Can I deny bail?
Your Worship, still, if prosecution is ready to proceed, you can deny bail. You see, the most important thing is court to make circumstantial directives that are not only intended to have the accused person returned to court, but also to serve justice. Because this is a matter which is a bit complex, it's unusual, this is more of cyber, whose investigations can never be covered within the 2 months because of the so many technicalities involved. These are things Your Worship Court has to take into consideration. And it is our plea, Your Worship, that whereas court has the powers, we are asking as a prosecution that we be given time in the interest of justice to just verify, because it would also, court would also be taking a risk to consider a surety substantial, yet in actual sense, they are not substantial. So it is better, and it is actually better and safer to make a ruling knowing that the sureties are not substantial, but releasing the suspect on personal cognizance. And this is what we are speaking to, Your Worship. We would want to help court to make a reasoned judgment and to make a better precedent, because the sureties presented are totally different from the first sureties, and that explains a lot. Why has the applicant opted to produce different sureties from the ones he produced last time? That is an issue that comes to the back of this court, and this is what we want to help court with. And this cannot be done within hours. We need to verify, and this is you have had Butaala. Butaala is so many miles away from Kampala. We ask court, with all due respect, to just offer us this opportunity to also see that we are serving justice. We do appreciate the provision of the National Bank. We do appreciate. But we pray that we find out the authenticity of these sureties. Court could be handing the accused person to crocodile teeth.
Reply to Council Richard Kaza's submissions. Your Worship, in line with Article 23(6)(a), Your Worship, in line with Article 23(6)(b) of the Constitution, 23(6)(b) of the Republic of Uganda Constitution as amended, and case law by the Constitutional Court, Your Worship, that we availed court, and my land friend, the State Attorney, has not made any reference to. It is stated that here the court has no discretion, it has to grant bail because of the use of the word shall be released on bail. Your Worship, here to make it mandatory that where trial has not started, court should release the accused on bail on the conditions that it will put in place. Your Worship, I remind the court that in early March, when we prayed for bail, our land colleague informed the court that the prosecution was ready to start with the case. It had enough evidence which was overwhelming, and we could immediately start prosecuting the accused person. Your Worship, up to date, we are already informed that investigations are still ongoing, And the 60 days, it is more than 7 days past the 60 days, Your Worship. And since this provision is states that it's mandatory, we pray that if state does not agree with the sureties, what rules on our prayer for mandatory bail in accordance with the law? Your Worship, state mentioned about the different sureties. We presented sureties to court for the comfort and confidence of the court that this person, in case of anything, there are people of responsibility that will ensure that he appears back in court. Your Worship, these sureties are all sisters to the mother of the accused. They are older.
I think the Worship, yes, we will do this one. This is a repetition of what we have submitted.
It is 2 months and 7 days, Your Worship.
68 days?
67 days now. Your Worship, I rely on the Constitution, Article 23(6)(b). Your Worship, in addition to the constitutional provision and the case law, the accused has sureties that would pray to present before court.
Your Worship, the accused has presented 2 sureties for this court, and the first surety is
as per Annexure B, the accused person is charged with this 8 counts, 4 for hate speech and 4 for malicious information, sharing malicious information. These are serious kind of charges or counts which are multiple in nature. They are multiple in nature. Coupled with the fact that he was on fishing spree for witnesses, for sureties whom we believe are commercial, we pray that this court denies or dismisses his application for bail. To the worst, just in case this court has closed its eyes to these glaring gaps in this application. We pray to have that on. Just in case this court closes its eyes on the glaring gaps in this application, right from the applicant, the sureties, then we pray for extremely stringent terms.
What are most extremely stringent?
Your Worship, very term of about 30 million. Yes, this is prosecution. I mean, this is prosecution.
So you pray that he pays 30 million cash?
Like we are saying, in case this court, which of course our prayer is that court should dismiss the application, but in case this court exercises its discretion, then the terms should be extremely harsh. Not harsh, but deterrent. Yeah. And Your Worship, these terms we are talking about, which we even don't want to mention, but for example, depositing a land title,
his names.
Depositing a land title. If court is inclined, he has to deposit a land title in his name. Yes, demonstrate by way of an account to show that he's worthy, trusting himself. Your Worship, then also depositing his passport. Among others, who saw
Your Worship, I would like to object to that.
You will get the heads up here.
These are investigations. You can also present your work. Your Worship, is there submission therefore that the applicant is safer in custody? But besides, it is the applicant is an administrator of Presure, of a Twitter account called Presure 24/7. He's the administrator of that account. From my investigation, Presure at Presure 24/7 at Presure slice 24/7. I refer to paragraph 11 of the affidavit. I refer to paragraph 11 of the affidavit. TikTok.
Yes.
TikTok. Yeah. Yes. What is the implication? Is that once he gets out of custody, the possibility of him deleting and interfering with the investigations are so high. And yet this TikTok account is a source of investigations. Josh, I'm not an expert, but once you're an administrator, then you're capable of doing anything on that account which you administer. Besides, that said,
You're saying we with the investigation?
yes, exactly.
Conclusion?
Your Worship, I just want to furnish you with a copy of the ruling of this application 045, 046, and 047 of 2015. I just want to highlight something small before I talk about the submission which my brother brought in later. When the applicant appeared before police, he presented his place of abode as Kauga Village, Mukono, Upper Mukono Municipality.
Place of abode as?
Yes, as per Annex B. As per Annex B.
The four of you and this one of us joined.
Thank you, Your Worship.
This was senior. Who's Mr. Bassar? Mr. Bassar, please.
Much of that, Your Worship. Your Worship, I will carefully listen to the Land Chief State Attorney. The Land Chief State Attorney's emotional submissions.
Objection, Your Worship.
On the
Your Worship, I want to first address court on the next.
I'm going to give you Friday. And on Friday we are proceeding, whether it rains or shines. And we have only two cases on that day, Nambi and this one. Nambi, we are not proceeding most probably. So let me give you Friday. Friday is what?
Friday will be.
But we don't have a full day hearing because we may leave this place at 5. And this time we don't bring stories. This one is lame, this one is having a problem. No.
And Your Worship, for court report today,
It's unfair that people are bringing witnesses, we are not proceeding.
they talk from our country, Your Worship.
You cannot, you go to talk on this head.
Yes, I'm here.
judgment and to make a better precedent, because the sureties presented are totally different from the first sureties. We ask court, with all due respect, to just offer us this opportunity.
Upon the land, Senior State Attorney Evans has said the state needs 2 weeks to conclude investigations. Counsel for the accused has applied for mandatory bail, citing Article 26, 6B of the Constitution Public of Uganda as amended, and also the case of Foundation for Human Rights Initiative versus the Attorney General. He has presented 2 sureties, Amakakali and Nabzale, and both maternal aunties of the accused person. The state has sought an adjournment to verify the authenticity of the sureties presented to court, which the defense has objected to. Article 26(6)(b), Article 23(6)(b) of the Constitution of the Republic of Uganda is quoted in marginal terms and it states, in the case of an offense which is tried by the High Court as well as by subordinate court, if that person has been on remand for 60 days before trial, then the person shall be released on bail on such conditions as the court considers reasonable. In the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006, the Constitutional Court stated that under Article 23(6)(b), where an accused person has been incarcerated for 60 days before trial, final offense by the High Court as well as the subordinate court, that person shall be released on bail on such conditions as the court considers reasonable. It went on to say that here the court has no discretion as to grant bail. I'm tied by the above constitutional provision and the above decision of the Constitutional Court. I am of the view that when an accused person has stopped the mandatory period on remand, court can only set bail conditions. It cannot adjourn the case for any other purpose, including investigation of sureties, because an accused person can be released on his own cognizance. In this case, the accused person, Musa Ibrahim, has stopped the mandatory period on remand, having been on remand for 60 days when the trial commencing, and hereby release him on bail on the following conditions as per Article 23(6)(b) of the Constitution. 1 is pay cash bail of 2 million. Each of these 2 sureties shall each execute a bond of 20 million, not cash. It deposits his national identity card in court, and is also given 2 weeks to deposit his passport in this court. It is not to mention the names of His Royal Highness, the Kabaka of Uganda, His Excellency Kaguta Museveni, Right Honorable Anita Among, and Honorable Nakosa Semugao, and any of his social media handles and who this case is heard and disposed of which of which is going to be cancelled. We had this matter on the 28th of May. It's now 16 days. The trial has not yet commenced. Upon the land, Senior State Attorney Evans has said the state needs 2 weeks to conclude investigations. Counsel for the accused has applied for mandatory bail, citing Article 26, 6B of the Constitution Public of Uganda as amended, and also the case of Foundation for Human Rights Initiative versus the Attorney General. He has presented 2 sureties, Amakakali and Nabzale, and both maternal aunties of the accused person. The state has sought an adjournment to verify the authenticity of the sureties presented to court, which the defense has objected to. Article 26 of the court, if that person has been on remand for 60 days before trial, then the person shall be released on bail on such conditions as the court considers reasonable. In the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20.
Is insecure. And actually being in custody is for his own benefit. Being in custody is for his own benefit. In fact, if I were him, I wouldn't even mention the word application for bail. First of all, Your Worship, I have a copy of this ruling for court.
You are saying that it's safer in prison?
It's safer in prison, Your Worship. And Your Worship, it's not only speculative, but I would refer you to paragraph, just a minute. He's on phone to make money from phone. So that makes him too uncorporate and trustworthy.
So court can't trust a person survived on a phone.
Where would you find him? Where is his place of address? Because, Your Worship, I don't want to speculate. But the issue of address is a matter of fact. But besides, prosecution pledged to verify the documents. If, for example, my own brothers knew of that, maybe probably they took instructions prematurely without interviewing the applicant. I'm not accusing them, but they should have brought this information that time when they were making this application. This is an afterthought. This is an afterthought because they are operating no obstruct. As the prosecution is proceeding to verify the residence of the accused person or applicant, they are busy operating in abstract because we should have verified that. And now that we can't verify that, we pray that Your Worship Court finds him further doesn't have the space of a court. Your Worship, in a nutshell, this accused person, as per Annex chapter,
Your Worship, that person should be released on bail on such conditions as court considers reasonable. Your Worship, I also further rely on the Constitutional Court authority. May you please share a copy with the court. Your Worship, this is the authority of Your Worship, for the record, Masaba Raphael Gideon and Ikapuru Tumsini.
Your Worship, this matter is coming up for mention. Inquires, Your Worship, about the conclusions. We are very poor.
That we are serving justice. We do appreciate the provision of judicial bail. We do appreciate.
we get back to me. So what are your instructions, Mr. Yamkam?
Which one?
Witnesses proceed with the main.
Yes, this is just something. We fix the main application and you are supposed to call witness on Friday. So Mr. Yamkam, I tell you plan to be on Friday at 9 o'clock because we are certain, I think we don't have any other cases. So we have only one case that they are not fixing any other. And they have vision of the constitutional court. I am of the view that when an accused person has stopped the material period on remand, court can always set bail conditions. It cannot adjourn the case for any other purpose, including verification of sureties, because an accused person can be released on his own cognizance. In this case, the accused person, Musa Ibrahim, has stopped the material period on remand, having been on remand for 60 days when the trial commencing, and I hereby release him on bail for the following conditions as per Article 23, 6B of the Constitution. One is pay cash bail of 2 million. Each of these two sureties shall each execute a bond of 20 million, not cash. Is deposit his national identity card in court, and is also given 2 weeks to deposit his passport in this court. Is not to mention the names of His Royal Highness, the Kabaka of Uganda, His Excellency Kaguta Museveni, Right Honorable Anita Among, and Honorable Nabosa Sebugao, and any of his social media handles until this case is heard and disposed of with, which of which is going to be cancelled. That day is met on the 28th of May, 2024. You mentioned the name of the Kabaka, you mentioned the name of the President, you mentioned the name of Right Honorable Anita Among, you mentioned the name of Sebugao, any of your handles. You come back here, we shall pass your bail. This must happen. This you should abide until this case is concluded.
They do not even indicate any sickness. They don't, because
Like, so
they
this
say
is
no increase in malaria parasites. I don't know whether the
This is unfortunate, but you know what? Everything comes to an end. Let's have Friday. That's where I'm coming. Can we be here on Friday?
Your worship,
Friday is one.
Friday is third.
Friday 3rd. Let's be on 3rd.
You are praying for criminal summons. Yes, on that day, that's the main case. Your worship, will someone order our witnesses on that day?
Are they too long?
Where the 4 witnesses were here? They are there.
We also, in the interest of justice, that the state is given some time to be able to respond to him, as he has already intimated to court that he intends to object to it. Perhaps court would.
So how are you affected if the same documents are sent to one again? How are you affected? The same exact documents that were sent at police, we send them to one again.
Your worship, that one
You've been inconvenienced.
if it's for their own case, but ours,
What is their case, not for your case?
yes, for theirs, we have no problem.
Mr. Biamka,
You us, we shall present our.
what is the complaint in this matter? Do you have any problem with this step?
to crocodile teeth. this is Afree.
Foundation for Human Rights Initiative versus the Attorney General, Constitutional Petition number 20 of 2006, and in particular, Your Worship, at page 12. At page 12 of Your Worship in particular, court agreed with Article 26B, where Your Worship, court rephrased what I read to court, and added that here the court has no discretion, it has to grant bail because of the use of the phrase "shall be released on bail" appearing herein.
Musana Ibrahim amanyiddwa nga Presure akomezeddwawo mu kkooti ya Buganda Road mu maaso g'omulamuzi Ronald Kayizi ku misango egimuvunaanibwa okuli okuyisa olugaayo mu Bwakabaka, okuvvoola Ssaabasajja n'omukulembeze w'eggwanga n'abalala n'okusaasaanya obubaka obusiga obukyayi ng'ayita ku mitimbagano. Bannamateeka okubadde Masaba Raphael Gideon ne Tumusiime Kakulu basabye kkooti okwesa obuyinza bwayo ng'eyita mu tteeka ery'omusibe okumala kwa limanda ennaku 6 nga tannawezesebwa kkooti eyimbula omuntu waabwe kubanga mu kkomera amaze ennaku eyisibwa mu 6 eziwa omusibe eddembe okuyimbulwa awatali kakwakulizo konna okusinza ku mateeka g'eddembe ly'obuntu.
We should be to make it mandatory that where trial has not started, court should release the accused on bail on the conditions that it will put in place.
Presure yeyimiriddwa bannyina abato okubadde Lydia Wakoli ng'oludda lwabi lukulembeddwa mu Richard Birivumbuka basabye obudde okwetegereza ebikwata ku bazze okweyimirira omuvubuka ono.
But they should have brought this information that time when they were making this application. This is an afterthought.
Omulamuzi akanyiza ne bapulida ku kya ssemateeka okukugira kkooti okugenda mu maaso n'okugalira omusibe amaze ennaku 6 mu kkomera, era wano wasinzidde n'amuyimbula wakati mu kumusaako obukwakulizo omuli okuwaayo ensimbi obukadde 2 ez'obuliwo ate bamuyimiridde obukadde 20 ezitali za buliwo. Amulagidde obutaddamu kufulumya kigambo kyonna ekikwata ku Ssaabasajja President Museveni, Sipiika wa Paalamenti, baminisita n'abalala nga singa ebigambo bimusimattuka n'addamu n'ayisa abakulu bano mu kamwa ke okweyimirirwa kwe kkooti yakusazaamu.
You mention the name of the Kabaka, you mention the name of the president, you mention the name of Right Honourable Anita Among, you mention the name of Senghor, any of your handles. You come back here, we shall pass you bail. This you should abide until this case is concluded.
Kkooti era emulagidde okusingayo passport ne ID mu kkooti mu ssabbiiti 2 okuva kati.
Is deposit his national identity card in court and is also given 2 weeks to deposit his passport in this court.
Kkooti omusango egwongezaayo okutuusa nga 28 omwezi ogujja. Joseph Innocent Senfuma yakusakidde gwino ku Kati TV.